Welcome, everyone, to this legal office hours. Today's topic, common legal diligence issues and how to handle them. My name is Will Smith. I'm the host of the podcast Acquiring Minds and a partner in Minds Capital, a fund that invests in independent sponsors. Attorneys James David Williams and Bill Barlow are going to host our session today. You know Bill and James David as partners in Barlow and Williams, a practice that specializes in small business M&A. They are at the front lines of our market. Their focus is on helping searchers, sponsors like you all do your deals. They also represent sellers, so they see both sides of transactions in our market. This is their 13th office hours with Acquiring Minds. Thank you, guys. You should also watch, you audience should also catch their other sessions. We have recordings of all of those on the Acquiring Minds website. The way we run these is Bill and James David have a presentation for you. They will give that presentation and then we'll do Q&A. To ask a question, use that Q&A button there at the bottom of your Zoom window. And so not the chat and not raise your hand. I sometimes see folks raise their hand. That doesn't really do anything. Questions via the Q&A button. If you have a very in the weeds question, maybe a question about a live deal, sometimes those can be difficult to ask and ask live for, in this setting, but feel free to ask it anyway. And James David will answer after the fact. He'll follow up with an answer to you separately and privately. We are recording this session, so you'll receive a link to this recording in the next 24 hours or so. That will also have a link to the slides of today's presentation. And finally, connect with Bill and James David via LinkedIn. Links there, their email address is there in the chat, as well as the Barlow and Williams website. And with that, guys, over to you.
All right. Thank you, Will. As he said, we're Barlow and Williams. We are an M&A law firm. That is all we do at this point. We specialize in representing buyers and sellers of businesses anywhere up to about $5 million in EBITDA. What sets us apart is that we do all of our engagements on flat fees, and we use milestone-based payments. It's a bit of a unique structure, but it's how we do it. We also deliver partner-level support. When you work with us, you work with us. We don't have associates to farm things out to. So let me pull up the slides here and share my screen. There we go. All right. Got that set up. So this month's presentation is the always sexy topic of legal diligence. It is the sort of thing that can feel like pulling teeth sometimes, but if you don't do it, you can have some real gotcha surprises. So we'll just start here. So the first question that you always want to ask, and if I can figure out the answer to, is who owns the business that you're buying? You would think this would be simple, and many times it is, but sometimes it isn't, right? Because if there are minority owners, they could have consent or veto rights over the transaction. So what that can mean is that you need to ask for the operating agreement, the shareholder agreement, whatever, the partnership agreement, whatever it is that the seller has. Because if it turns out that someone's angry ex-wife can veto a transaction, then you might have a problem. And we've seen that scenario play out. We've also seen scenarios play out where 20% holder could hold up a transaction, so the transaction had to be restructured to get around that. So that was a fun situation too. But always something to look at. A lot of sellers won't necessarily understand this when you ask either, right? So you really just ask for the documents themselves, and then when you have people like us look at them, but it can lead to some kind of odd negotiations if it becomes relevant. Um, Next thing that you'd want to look at is, what are the key contracts for the business? And this is going to look different depending on the nature of the business. There can be businesses where there really aren't written contracts at all. And that's a little scary when that's the case because I'm an attorney and I try to look for risks, but we have people buy those businesses. It can be a franchise agreement, it can be a distribution agreement, could be a government contract, could be a collective bargaining agreement, right? If you're dealing with a union workforce. But whatever those are, this is going to be one of the big things, one of the first things we're going to look at, right? Because it can affect deal structuring. It can affect, it could be that you need to get approval from one of those third parties, especially a franchisor would be an obvious example for the transaction to work. If you need to know those things early so that you can get out in front of them. Because otherwise you can have a situation where your deal gets held hostage at the last minute. And those are not fun places to be because at that point you don't have a lot of leverage. Um, it can also affect kind of deal structuring um, in different ways. And then sometimes lenders have special opinions about some of these contracts too. Again, key contracts can mean a lot of things. It can be employees even, right? What's your general manager's contract say, for example? Um, But the biggest thing in diligence is to get those agreements in early so that you and your attorney can look at them and strategize the way forward. And kind of a subset of that is can contracts be assigned, right? So in SMB acquisitions, the default structure is that you would be purchasing, you would be purchasing the assets of the business and not the equity of the business. And in an asset purchase structure, you need to assign contracts as part of that transaction, right? Those contracts are often part of what you're buying. You don't all assign everything, but you would assign customer contracts and things like that. But certain contracts, government contracts or contracts with Fortune 500 companies or really important licensing agreements, can't be assigned freely. Right? That's sort of a leases often can't be assigned freely either, but that's kind of a separate issue. But if you have big government contracts, then it's likely that that's going to force a transition or force you into an equity purchase structure, a stock purchase structure, in order to maintain those contracts. Um, there can be additional complications around qualification periods and ability to bid for government contracts, but we'll put that aside and just focus on the contracts themselves, right? Because those government contracts will be with a specific entity and they can't be assigned without, potentially having to go back through a bid process, which you don't want because those government contracts are often a big part of the kind of ongoing revenue that you're buying in the business. So one of the reasons we ask for a lot of these big contracts early is to make it clear what the transaction structure is going to be, because if we need to transition from an asset purchase to a stock purchase, it's better for us to know that sooner because it changes some of the other diligence that we do, right? It makes certain tax diligence, which we don't do, but financial people do, makes that more important. It makes some of the litigation diligence more important, etc. Uh, so again, some of this you'll know probably even before an LOI. Some of this you can kind of guess from a sim as far as what the key contracts are going to be. Contract assignability, you're never going to be able to know before signing an LOI, but we want to ask for these big contracts early. That way we can sort out these large structural issues. Next question in diligence, and this isn't really a legal question so much as a business question, financial question. But do the financials withstand scrutiny, right? You're going to be presented with a series of financial statements, often a balance sheet, a statement of profit and loss, and some tax returns for a trailing, 2 or 3 years often, sometimes longer than that. And you need to ideally verify, you want to verify the accuracy, the veracity of those numbers. You don't want me doing that. I don't make Excel models, I break them. So you want somebody who actually does financial reporting, and specifically financial reporting for SMB transactions, right? The quality of earnings, which is what a QOE is. A QOE can look very different for a business in the kind of lower market than it would in, say, the middle market, right? As we kind of say sometimes, right? There is no such thing as audited financials in small business acquisitions. And so you want your QOE provider to be used to kind of messier books, right? Often sellers who have been on cash accounting, you'll need to convert them to accrual accounting for the purposes of your lenders, right? That can be a messy process. In that process, sometimes those SDE numbers or EBITDA numbers can drop a lot. We've seen a lot of deals die because of that. I mean, we call financial diligence the graveyard of SMB acquisitions, sort of internally. And while we're on this slide, I'll speak a little bit to kind of the diligence timeline overall. Maybe should have started there. You'll do a little bit of diligence pre-LOI, but you're really beholden to what the broker or the seller provides you. So they often withhold some of the kind of basic information that you need to do a lot of this diligence. But once you're under LOI, that's when your diligence really kicks in. And the way we do it is we sit back on the legal side and let the financial diligence largely play out first. We do that because we know just sort of the deal dynamics, and we don't like our clients to incur broken deal fees. So once you're under LOI, engage a QOE person at that point, get them started. They'll send a bunch of requests, and then they'll collect that information. It'll take them a couple of weeks once they have the information to prepare their report. And it's during those couple of weeks that we will send the legal diligence requests, usually. Sometimes we invert things a little bit to get in front of, to see particular contracts sometimes. But often we don't send the legal diligence requests until the financial diligence people are actively working. And we do that just to keep things, keep the train moving, keep the seller engaged, and keep momentum going towards closing. Bill, you want to do this one?
Yeah. I've been my voice is a little weak today, so James David's been kind enough to jump in for a lot of this. So the next point is basically the employees. So you're going to want to get a sense of what their roles, their compensation, their titles are. Are they hourly? Are they not? Sometimes you have issues with classification. So basically, usually to not pay payroll taxes, they'll pay employees that are really W-2 employees as independent contractors, which obviously isn't right. You also want to know what their benefits package is. Like, do they have a 401k? Do they have health insurance? And you'll work with the administrator to deal with that. But again, these are things you need to kind of be aware of. Another thing, we kind of touched on it before, collective bargaining agreements. You'd be surprised. I think we've had something like 2 or 3 deals just this year where collective bargaining agreements have been in place. So a lot of times you don't think that's the case for smaller deals, but especially if there's a specialized trade involved, don't be surprised if you have some collective bargaining agreements. The other thing is if you have key employees. So if you've got somebody that really is running all the operations, or even a lot of times, more commonly, somebody who's the real kind of lead on sales, you want to make sure you know what that arrangement's going to look like post-closing, because the last thing you want is to close on the business, and then the day after, the lead sales guy leaves and goes to a competitor, right? Or starts his own thing, So if you have people like that, then you need to lock those contracts down. And that tends to be an issue of contention with the seller, because the seller often doesn't want you to speak to employees until you've closed or you're right next to closing. You want to speak to the employees as quickly as possible. And especially if you've got a employee like that, like key sales guy, you want to make sure you understand that relationship. We already talked about this,
Yeah.
proper classification.
Yeah, no, I'll double down on it, and then I think immigration issues on the next slide. But the employee classification issue, right? It's a question of state law, so there is some variation, and there are actually multiple tests depending on where you are in different states. There is no nationwide standard. But what you need to know is that if people are misclassified, that you can face huge penalties from state agencies. And regardless of whether it's an asset purchase or a stock purchase, if you hire, if you keep all the employees, the state is just going to treat you as if you're the employee going back to the employer going back. Right? So you're going to be assuming that sort of history, whether it's an asset purchase or a stock purchase under most circumstances. And so if your seller has been calling people contractors and they're actually employees, at those penalties, they just rack up and rack up and rack up and rack up. And then you've got to add, the overtime you didn't pay. And then there's extra penalties for that. And then there's, the payroll taxes that you didn't pay. And there's extra penalties. But it can get bad quickly. Another thing around classification is, you want to see I-9 verifications for all the employees, right? You want evidence that they're all legally authorized to work in the United States. There's sort of different levels of I-9 verification, unfortunately. I mean, there's the form itself, and then there's kind of a lot of times we don't always see sellers to have kept copies of the supporting documentation for those I-9s. So if you're doing this process yourself, as you hire employees, make sure that you take a scan of their passport or the driver's license or social security card, whatever the supporting documentation is, because otherwise it's much harder to verify the I-9. But ask for the forms, make sure the forms are there. Hopefully the supporting documentation is, but regardless of whether it is or not, right, if you're doing this yourself as an employer, keep a copy of the supporting documentation. Just makes things easier for you.
Can I jump in with a couple questions on this stuff, guys?
Yeah, go ahead.
First of all, when you talk about misclassifying or properly classified, just to be clear, that refers to 1099 versus W-2 only. That's the classification. It's not like there's some other thing.
That's the classification. Yes.
Okay.
There can also be whether someone is overtime eligible can be a classification issue. But the more common issue is independent contractor versus employee or 1099 W-2.
And so the way to diligence this would be ask the seller for all of the quote contractors that they work with, and then kind of scrutinize the substance of the work.
Yes, I mean
person by person by person.
Yeah, we're going to ask for all the agreements, right, with contractors and employees, and then we kind of want to know, right? We'll ask for an org chart too, and you kind of want to get a sense of roles. But if somebody is in certain roles, like if somebody is in back office kind of administration type role, say. Well, that person's going to be an employee, right? Almost every time, unless they're truly outsourced and somewhere else and doing it fractionally. Like if you're in the office being a secretary, you're an employee. So if somebody like there can be obvious things like that. But then, but it's fairly common for salespeople, right? Salespeople can be on a 1099 commission on a much more common basis. So you just you match it. It's a little bit of pattern matching.
Mm-hmm.
But you want to, we ask for all the agreements, more or less.
And also for people that are like going out and doing work, a lot of times the question is, are they project by project or are they like, you're just paying them, every time? Because where we often see this coming in is like, if you're just hiring somebody for the project and the project's done and that, you're not paying them anymore, that's much more like an independent contractor. If
Yeah.
you have somebody that you're just using them for every project and you're just paying them 40 hours at whatever their hourly rate is constantly, and you're calling them an independent contractor, that's a lot dicier.
Yeah. And then, isn't in some certain states like dictating when they work for you, their hours and so on is one of the other filters. And this was to your earlier point that like all these little rules, they're variations state by state, right?
Yeah, there's some variation. California is one of the more aggressive ones, maybe to no one's surprise. But if you control when they work or what tools they use, that can be something that's one of the best. And that could be, physical or digital tools. When they work, where they work. Yeah.
And then if you go through, you business buyer, and you find some cases where folks who've been 1099 should have been W-2'd, and you convert them to W-2s upon taking ownership of the business, are you still liable for the time they've been misclassified, or
And
is that all
so
you needed to do?
And so that one is a little bit tricky, right? The best practice, if they need to be W-2s, is to convert them immediately. And then if it comes to it, uh, you're sort of just mitigating risk at that point, right? And if it comes to it and you do face an investigation from one of these state agencies, you would at least have a very strong claim in front of them to say, I did what I needed to do. And
Yeah.
I've done everything right during my ownership.
Yeah.
So it's much, it's just much less likely that they would impose punitive sanctions on you. Does it absolve you of all risk? No, but we're about managing risk, right? There's no such thing as a risk-free transaction.
Yep.
You can
Yep.
also get special indemnification from the seller.
There's
for
that too. Yeah. Yeah.
And somebody's asking, back to your point, James David, that it can be with salespeople, this 1099 structure can be common. So is that in fact a classification, miscategorization? That shouldn't be how they are, even if it's a kind of a common practice?
No, it can be perfectly reasonable. They have to fit in the tests. And
Okay.
some of it, with them being commissioned, it depends on whether they're commissioned or salaried too, can kind of impact this. And there's a sliding scale. Sadly, there's just no clear rules for any of this, at least nationwide. But if they're more on salary, then maybe they are. If they're more commissioned, then it looks more like a true contractor. Yeah.
Great. Well, we keep getting more and more questions from people now. There'll be questions about subs in like a construction business or a trades business,
Mhm.
subs who might only really ever work for the target business. Anyway, so I don't want to keep. I think the point here, maybe for the audience, correct me, guys, is that it's going to be pretty case by case, and this is precisely the sort of work that you would want your attorneys to scrutinize, right?
Yeah, and there are also going to be limits, right? You're not going to be able to look at I-9s for the subcontractors in a construction business most of the time, right? So that there are limits to what you're going to be able to know. for some of this too.
Okay. Thank you. Let's carry on.
Okay, next topic is permits and licenses, especially relevant in the trades, but can be relevant in other businesses too. So we'll just sort of ask early, like and this is kind of one of our, like, what licenses do you have? What licenses, what permits do you have? We'll just ask the seller. Sometimes it requires explaining what that means, but I mean, you want to know everything, right? They might have to register with multiple taxing authorities. They might have registered for sales tax in different states if we're in certain, if we're in an e-commerce setting, or there might be a master plumber license in a business. Well, okay, is that held by the entity? Is that held by an individual? Multiple individuals, right? If you are in the trades, right? What licenses exist? Who holds them? Right? You want to know these things early, because it can affect deal structuring. If the entity holds a license, then possibly you have to buy the entity. If it's individuals that are holding key licenses, well, okay, what redundancies are there, right? Is it just one person that holds the whatever master license is needed? Well, in that case, what's the plan around that person, right? Because if that person is the seller or the seller's child, then you might have a problem on your hands, right? And so you need to know that. Your lender is going to kind of insist on a succession plan around licenses too, so it's better to just go ahead and get out in front of it. But it's about, especially in the trades, a lot of times it's just about risk assessment. And the more license holders there are, the safer the business is, right? Because if it's just one person or two people, then they can hold you hostage, especially if you don't hold the license yourself, right? If you hold the license yourself individually in the trades, then different scenario. But regardless, you want to know what the situation is so that you can understand the business case that you're walking into.
Next question, any issues with real estate? So we kind of mentioned this before. This especially was a bigger issue before the rule changes. I mean, but now it's still an important issue because a lot of lenders still want to see leases for the term. What's the relationship like with the landlord? We've seen issues where the landlord is simply not willing to assign the lease, and that kills the deal, right? And you want to get ahead of it because the last thing you want is to do, a week before closing, you ask the landlord says no. We've seen that happen, and it's really unfortunate. And the other thing is, along with that, is how important is that particular location, right? It can be the case that it's like an office, generic office, and doesn't matter. It can be the case that it's a very key location. You're in a small town. This is like one of the, the place where this location has been, and there's not really any other locations for it. That real estate could be very important. You'll often want to negotiate to have new leases post-closing that allow you to have the length of the term of the loan. If you're buying real estate, if there's any manufacturing involved, the lender will often require you to do phase one. Sometimes even without manufacturing, they'll just want you to do phase ones. Start that process early because sometimes they come back with phase two. We have one deal that happened this year where phase one came back and they just said, oh, I think we should have a phase two. It delayed the entire process by several months and it cost a lot of extra money. Phase two came back clean, but it still impacts the timeline. So, if the bank is saying you need a phase one because you're buying real estate, get ahead of it. Do it as quickly as possible.
Yeah, and if you're doing an SBA loan, the landlord is going to have to sign a subordination agreement with the SBA lender. So that we've seen that be an issue too sometimes. So again, another reason to have the conversations early.
What's a phase one, guys? in phase two?
Yeah, phase one is it's a type of environmental reporting. So it's an environmental assessment. And it's basically, is there any toxic chemical spills? And then if there is something, you proceed to a phase two and then potentially to remediation that. And I don't know, we don't do them ourselves. So
They basically go out to the property, they take soil samples and then they take them back to a lab and see if there's anything, problematic. Sometimes what ends up happening is they see like, oh, there's little diesel or something, like just because, a car is driven over it. So you don't know, random times they'll end up saying, and they kind of have an incentive to ask for a phase two. So, just keep in mind, even though it's a clean facility, phase ones will often come back like, oh, well, a phase two would be better. And then you could have a conservative bank that's like, well, they said they want a phase two. We've seen that happen several times. So just get ahead of it.
okay, next issue, which is one that I'm actually dealing with on the sell side right now because we've got some renewals that are ongoing. Does the seller have any registered intellectual property? So registered intellectual property means patents, trademarks, copyright, something that's actually filed with the government. And the reason you want to get out in front of this is because if there are any patents, trademarks, copyrights, there's expiration dates, right? You have to do renewal filings for those. And you don't want to make sure that you don't want you don't want them to lapse. But if they lapse, then you have to eventually reapply completely, and you might not be able to get it in a reapplication. It's much easier to do a renewal. But regardless, you just want to find out so that there aren't surprises, because those surprises can be really bad. Just ask Keurig about that with their K-cups, if you want to look up a horror story. Another thing that you want to look at or know about if you can is obviously you don't want to buy into a lawsuit, right? So this is something that we just do litigation searches in public databases. You can't know everything, right? People could come out of the blue. But if there's an ongoing, if there's an ongoing litigation of any kind, you want to know that. You want to know what it looks like. You want to be able to assess it, because sometimes it's just a strike suit and it's irrelevant. Sometimes it's going to be settled, a month later. And then we've seen anything from that to ongoing litigation between the seller partners, and that kind of stalls everything. And then also in the interest of searches, so you're going to do a litigation search, or you'll get a litigation search done. You also do a lien search. Your bank will do this too, just to make sure that the seller owns all the assets free and clear. This can lead to the seller needing to pay off a line of credit, pay off an SBA loan that they had outstanding, other bank loans that they had outstanding prior to or even at closing. But you just need to make sure that when you do complete the transaction, that after the transaction, you own the assets free and clear of any liens that you didn't put on the assets, right? I mean, the SBA loan will put a first priority lien on all the assets, but you don't want there to be anything else. If you do have physical assets, like if you're buying a manufacturing facility, also you want to make sure that as much as you can, that the machinery actually works. Same way with vehicles, if you can, like do an inspection, walk around the place, and if you can, get somebody who actually knows what they're looking at, whether that's you or somebody else, to actually inspect the equipment. I think nope, we've still got a couple more. So tax, even in an asset sale, certain tax liabilities, cough, cough, sales tax, cough, cough, often carry forward. And it's important that you understand what the potential exposure is, right? If you do an asset purchase, you're not assuming their income taxes. you could be assuming their payroll tax liabilities, right? We talked about that earlier. But sales taxes, states are very aggressive about sales taxes, especially relevant if you have an e-commerce component to the business, right? Because there are different thresholds in different states and different nexus requirements. And the Supreme Court really allowed a free-for-all about, it's been several years ago now in the Wayfair case. But you just want to assess it because you could have, tens of thousands of dollars in liabilities just to multiple states if the seller's not been doing things correctly. And if you're doing a stock purchase, tax diligence is even more important because you're taking on all of their tax history, including all of their income tax filings. That's the last one. Okay. The last thing is insurance. Insurance diligence often kind of follows after legal and is usually a separate theme. And you want to talk to an insurance broker, or there's specialist diligence people for insurance too. But we always ask, like, what is the insurance stack of the business? And one of the reasons we'll ask is sometimes key contracts will mandate, you have to have general liability insurance of this amount, and it has to cover, $5 million and $1 million per occurrence. Okay. That's a big contract you have, but you've only got a $2 million GL policy in the existing business. Obviously, that's a problem. You're going to have to increase the insurance post-closing. And so we need to build that cost into the financials. So something like that's why we asked that question. So we'll let that wrap up the presentation. This has been a little bit of a different cadence than the others because of Bill's voice, but hopefully people aren't too tired of hearing me talk. So
Never.
Great job, James David. You carrying us all here. Thank you. So, can I turn to a couple questions?
yes.
This is a particular case, but pretty easy. The seller owns the building. I'm looking at a deal. Seller owns the building, excluding the building from the deal. I'm going to lease the building from the seller. Is a phase one necessary in that case, since the building's not part of the deal?
Usually not. It will depend on the lender a little bit, but usually not.
Okay. Okay, great. This one doesn't pertain to today's presentation so much, but I think it could be helpful for a lot of people. Please discuss the legal mechanics of seller financing. How is that rate, the borrowing rate, typically decided? Standby periods and any other key features. This person is looking at a deal where the seller might be open to fully 50% seller financing.
Okay. So seller financing, it's a form of debt, right? How it gets negotiated, it's a bit of a crapshoot. How is the interest rate set? And people make up numbers. That's how it's set. It often does not incorporate the actual risk profile of the debt because seller debt is often subordinated to senior, right? It's often junior debt. And the interest rate doesn't always take that into account. And that's in your favor as a buyer. So
yeah, I see it's often lower than the SBA loan, considerably often.
Yeah, and that
Which
would never be the case if you were dealing with big credit funds in New York. How it works. So standby. So it's just seller financing. It's just like a loan, right? It'll be written as a promissory note. It's a loan document. And it'll have, right, it's going to be this amount, this interest rate paid over this term. Right. And there can be monthly payments, quarterly payments, semi-annual, annual payments, balloon payments, whatever. A standby period means is a period where there's no payments being made. And a standby can be There can be a partial standby where you're paying interest, but not principal. There can be full standby where you're not making any payments. There's different, sometimes interest accrues during a standby period, during a full standby period. Sometimes it doesn't, but all of this can be negotiated. If you are dealing with an SBA loan, right, there's additional kind of restrictions on seller financing, just around debt service coverage ratios and some of that. And then, with the new rule changes, there's in order for a seller note, seller financing, seller note, same thing. In order for that to count towards the equity injection requirement, there were changes to this, right? So it has to be on full standby, so meaning no payments for the life of the SBA loan, 10 years. Interest can accrue during that time, but no principal, no actual payments. And that makes it an obstacle in many circumstances, many cases. Sellers obviously don't want to wait 10 years to get part of their money. But there have been a few deals, a few circumstances where it has made sense. So we have seen a few. I'm working on a few deals right now where those full standby notes are going to be used in SBA transactions.
And to be clear there, James David, on this point about using a seller note as part of your equity, this is a nice, it used to be nicer. Now it's less nice for the reason you just described, but it can be a really nice feature of these SBA deals where if you are buying $1 million business and you need $100,000 of equity, 50,000 of those dollars, 5% of that equity could come in the form of seller note. So it's kind of quasi equity because you buyer are not bringing it as cash. That used to be much easier. Now that $50,000 that the seller note of the equity that the seller note represents, the seller is agreeing not to get it for 10 years. So you can imagine many sellers are just going to say hard pass on that. No. Sounds like, however, you guys are seeing some sellers be amenable to it.
There are some circumstances where it's happening. I won't say that it's becoming common,
but we kind of predicted that it would all but kill that, and it sounds like it's wounded it, but not killed it.
It has in certain places, and then in others, it's still going on. But
and just before we move to the next question, James David, a bit on forgivability in seller notes and why that can be a powerful lever.
Yeah, so forgivability, I'll limit this to the SBA context, because outside of SBA it can get funky. But in the SBA context, you can have a seller note that has certain conditions, right? So say it's $100,000 seller note, but if the business doesn't maintain its revenue levels, then the seller note is going to drop, right? So say the business is doing 400,000 in revenue, I'll just make these numbers up. And then if it drops below that, or we'll just say dollar for dollar reduction on the principal. So in the 12 months following closing, business only does 350,000 in revenue. Well, then the principal of that seller note drops from 100,000 to 50,000 in that hypothetical. That's a simplified version. There's all kinds of different simulation or scenarios for this, but that's sort of the basic mechanics of it. And those are allowable, at least in some forms under the SBA rules.
Yeah, and quite powerful. It's a great tool for a buyer.
Potentially, although they do make your offers less competitive relative to somebody else, some other buyer who is not offering those contingencies. So it doesn't be evaluated. It's also the case, I'll just say this because sometimes people don't know it, you can have more than one seller note in a deal. That is possible.
And how would that work, and why would you do that?
Yeah, it's possible that you have a guaranteed seller note, right? You have a contingent seller note, right? In order to, well, you want the contingent component, but not for all of it. right? So we have a deal right now using SBA financing that has that structure, but it has two notes. I mean, there's no limit in theory to how many seller notes you can have, but it gets beyond about, I've seen 2, I've seen 3, but beyond that, like, what do we do?
Great. Great. And just jumping back a little bit on the new rules about the standby feature and the 10-year, full standby, the 10 years.
Yep.
That's only in the case where the seller note is going to be used toward the equity injection.
Correct.
So we can still have 1 year, 2 year, whatever standby we want.
Yeah, you can still have any other note still works. That's one of the misnomers that I've seen a couple of places. Yeah. It only has to be 10-year standby in order to count for the equity injection. Otherwise, you're still limited by your debt service coverage ratio, but otherwise you don't have restrictions. Restriction.
Yep. Great. Maybe give us, as you did just on seller notes, James David, a very quick intro to reps and warranties and indemnities in the context of buying a business. Is that something that you can do in 2 minutes, or is that too big a question, too broad a topic?
Oh, that's fine. So as part of the purchase agreement, you'll be asking the seller, you'll make some as a buyer, but you'll be asking the seller to make a number of representations. And representations are just like the seller saying this statement is true. And that includes things like, I own the assets, right? I've paid all my employees everything that's owed to them. I've paid my taxes. There's no lawsuits against me, right? There's no government has to approve this transaction. There's a whole number of things. And all of those things will be in the purchase agreement. And then if it turns out that one or more of those statements, those representations is wrong or was false, and you suffer damages as a buyer, and there does have to be damages, then you will have something called an indemnification claim, right? Which is the seller, in basic form, is the seller saying, right, if any of these things are wrong, I'll pay you money as a result. And there can be special indemnities for unique things, but often it's just sort of general. And then there's often limits to the indemnification obligations, and those are often bifurcated between fundamental reps, which is things like taxes, and kind of everything else, which will have a lower limit. And then there will be sometimes detailed procedures about how indemnification claims get made, whether they get paid from the promissory note or directly out of the seller's pocket, right? All of those things get negotiated. But in the most basic sense, right, the representations are the seller making a number of statements, like all of these things are true. And then indemnification claims are what happens if those things aren't true.
Great. Okay.
And then hopefully you never have to look at any of that ever again. Because if you do, something's gone wrong.
Yeah. Maybe this is the part where we say what is usually obvious to people, that litigation is often just doesn't really make sense. It's often going to be not worth it.
Yeah, I mean, sometimes we would route these to mediation or arbitration, but if you're in litigation, you've probably already lost.
And by that you mean just it's going to be a bad outcome holistically.
Yeah, you're probably
You haven't
already
necessarily lost the case.
You're probably already facing a bad outcome, even if you win the litigation.
Right.
That's why we do as much diligence as we can on the front end.
Right. Yeah, so much of this exercise is preventative, because if it comes to it, don't assume that this stuff is going to just make
Yeah.
you whole, you as
It,
business buyer.
it all takes time, and you still have bills to pay.
Yeah. We've got a seller in the audience who says they've been offered an earnout sales agreement. Any call outs for that person?
Okay, so earnouts, I mean, one thing is if you as a seller are receiving an earnout offer from somebody and you think they're going to be using SBA financing, that's a red flag because that's not going to work with the
It's not
lender.
allowed.
So, so there's that. If we're dealing with earnouts and we're assessing them on the sell side, the biggest things are what's the relevant metric for the earnout, whether it's revenue, EBITDA, profit margin, but there can be any number of things, and whether what level of post-closing involvement the seller is going to have in order to try to earn that earnout. I mean, earnouts very common in private equity deals. And it's a different proposition for the seller if you are going to still be in the business post closing, right? If it's kind of a partial buyout where you're going to keep running it, or if you're leaving the business. So it's a little bit multivariable in how we assess them, and you kind of assign percentages to the different components of it and make your best guess. But it's definitely worth analyzing. And if you are the seller, you want to do that early and don't wait.
And I think a good rule of thumb or starting point in your analysis of the earnout is ultimately you want to be able to control as much as possible this thing that your performance is being measured against. So if you're going to be rewarded more money in an earnout because X happens, but you have very, the more you can control X, the better. The more out of control it is, the worse for you, obviously.
And sometimes that conflicts with what the buyer wants. Sometimes it works and everything's great, but when there's conflict there, it can lead to issues. And we've seen that.
A very common thing. Oh, sorry.
Go ahead, Bill.
I was just gonna say, a very common thing for that is if it's an EBITDA earnout, the buyer, if you don't have control over the marketing spend or other spend, the buyer could easily just put more money into that, and then, you lose because the EBITDA's gone down, even though the buyer's gonna take advantage of that. So if you are a seller and they're talking about EBITDA, just be very careful. We've seen that often not get paid and result in fights.
And if you're a buyer, because I know most of the audience is buyers, be wary of EBITDA-based earnouts or contingent seller notes, because anything that's an EBITDA calculation, those become lawsuits at a much higher rate. Just know that.
Yeah. And a common misconception or not understanding, which we're seeing in the questions, is so what's the difference exactly between a forgivable seller note and an earnout? Because they are actually quite materially different.
Yeah. So there can be differences in taxes, but the forgivable seller note is like, here's the note, you have this obligation, right? It's on and then it can decline, right? The compensation can decline. It's kind of some people kind of call it a reverse earnout. It's like you'll be paid X unless Y and Z happen, in which case X drops. The more traditional earnout structure is you get this amount now, and then if X, Y, or Z happens, then you'll get more. And the timing can be different, often is different. Earnouts can be a lot more complicated, but you can't do earnouts in SBA structures, right? So when we're dealing with SBA transactions, we're dealing with contingent seller notes or forgivable seller notes. And there's just much more many more limitations on what you can do with those.
Something that you'll see outside the SBA, which can be common, is you could say something like, I will give you 5% of EBITDA in the next year as part of the earn, right? Or something along those lines. However, even with a forgivable note construct, you couldn't do that, right? Because, there's no hypothetical limit to how high that EBITDA is. So just keep in mind, commonly people say, hey, I want to do something where the seller gets some upside and I give him some percentage of some metric going forward. That's extremely difficult under the SBA. It has to be forgiveness if something isn't reached, not a certain bonus, if that makes sense.
If I could take a stab, because I think I've heard it this way, which was helpful. Well, actually, two ways of thinking about this. A forgivable seller note is more maintenance of what's been true in the past. And an earnout is incentivizing what could happen in the future, or tying positive performance in the future to an earnout. Or this framing, a forgivable seller note is really about protecting downside, whereas an earnout is kind of incentivizing using upside as incentive.
Yeah.
You guys think those are fair frameworks to think about it? Yeah.
Because if you think about a forgivable seller note, if you have like $100,000 forgivable seller note, the most the seller could ever benefit is that seller note isn't forgiven, right?
Yeah.
Their upside is always going to be capped at the total amount of that seller note. Whereas
Yeah.
if you got a true earnout that says you get 5% of EBITDA, like in theory, if it does really well, the seller could get 200,000, 250,000. So as you said, the upside is much less in a forgivable seller note in general.
Great, guys. We're wrapping up here. Here is a question related to an episode of Acquiring Minds that aired. It's been a year now, but the guest bought a contracting construction business actually here in Northern Virginia, and seller misrepresented all kinds of things. It went bad, very bad, quite quickly, and ultimately there was a letter of confession that was involved.
Yeah.
And that just made it go from bad to worse and made the buyer kind of lose everything in the deal, I should say.
Yeah.
And well, actually kind of lose everything. But can you tell us what that is and how it could have been avoided?
So a confession of judgment, which is what you're talking about.
Mm-hmm.
Because I'm pretty sure I remember you interviewing this guy live.
At Georgetown, right? When we saw each other at Georgetown, James David. Yeah.
Okay. So yeah, a confession of judgment, which is something that a lot of states don't even allow, frankly. Basically is you signing in advance to that you signing an order in advance that's like, so where the other party to an agreement doesn't even have to go through a lawsuit. They can just take that document to court and you lose. Doesn't matter what happened. Short of like outright fraud, maybe. And so what I think happened there, if I remember, was it was attached to the seller note, if I remember. And SBA lenders will kind of work with you if you're not able to make payments a lot of times. Speak with them, get out in front, like communicate with your lender if things are going bad. But sellers, much less forgiving often. And this seller, or the buyer, was in default under both notes, both loans. But the seller took the confession of judgment to a judge and said, Your Honor, here we go. This person's in default. Boom, here's this piece of paper that he's already signed, and foreclosed on everything.
Yeah.
So I would I would not allow one of my clients to sign anything like that. Full stop.
And why would anyone sign such a one-sided, irreversible
Yeah,
document?
I don't want to, I don't want to disparage anyone who might have
Yeah.
done that. Because in that particular case, there were a lot of consequences for that individual. I would say the likeliest thing was just a lack of education, lack of understanding what it meant, uh, and a very overly aggressive person on the other side.
Yeah.
It's also something I've never asked for on the sell side.
Yeah.
Wouldn't wouldn't even contemplate asking for a confession of judgment.
I'll just add here because it's relevant. More likely, the fight is about personal guarantees. On terms of the seller note, they want the buyer to personally guarantee. And, sometimes, sometimes they feel very strongly about that. Sometimes, a buyer will say like, well, I'm personally guaranteeing the SBA loan. What's the harm of another personal guarantee? And well, the answer is that your bank is often less aggressive, as James David said, than your seller. So, just because you're having a personal guarantee on the SBA loan doesn't mean, what's the difference to have it as a seller note? Because your seller, is more likely to just be vengeful or crazy or whatever it is, and, feel like you've jilted them or whatever the issue is, and be more likely to actually pursue it. So just keep that in mind.
And then in that particular example, the confession of judgment just made that automatic.
Yeah.
Mhm.
Yeah. So be careful out there.
Great, great memory, James David. But what you guys just said might be a little counterintuitive to people, that the seller could be more aggressive than the big scary bank, bank corporate
Yeah,
that just
so
don't care.
an
But banks will
SBA,
work with you because they
yeah,
they want to resurrect this loan because they really
yeah.
just want to
I
get paid
mean,
back.
the bank is carrying, even if they sell off the SBA guarantee, which they do, like, they're still carrying probably a quarter of the loan on their books. And a bank is not good at running a small business, right? They're run a bank, right? So they don't want to foreclose, right? They will work with you. They don't want to foreclose because if they have to foreclose, they're just going to sell it for scraps and they're going to take a loss. So they would rather prolong their hold period, hope that you can turn it around and they give their money back.
And to Bill's point, they're also probably just more rational actors. A seller could get emotional.
Yeah.
For anybody who wants to listen to that episode in the audience, there it is. Just to put a link to it. A powerful, powerful story. Justin Willis always comment about how appreciative I and the whole community is for him sharing it, because it is a bad one. And if you're in the Northern Virginia area, Justin now actually hosts a monthly meetup. So you can go to that. To wrap, gentlemen, anything more to say? Anything you want to say more about Barlow and Williams? You shared a little bit about the firm. Anything more to say, or should I close this out?
Yeah, I mean, we work with buyers and sellers all over the country, across industries. We're both in North Carolina, so on Eastern time zone, but we work with people all over the country and sometimes all over the world. So go ahead and reach out if you have a deal. And yeah, we use, as we said at the top, we use flat fees for our engagements. M&A is all we do. It's all we've done for a few years now, and we try to deliver the best service we can for everyone. Uh, Understanding that everybody has unique needs, unique desires for their transactions, and so we do try to take those into account and strategize particular deals for particular outcomes.
Awesome. Well, you guys, word on the street are just doing great. Love to see it. These monthly office hours that you do are so helpful to everybody. So thank you for them. Thank you for today. audience note, I just put, again, James, David, and Bill's links in the chat. Connect with them on LinkedIn. There are their email addresses as well. This has been recorded, and you will receive an email with a link to the recording and a link to the slides. And James David, if we didn't get to your question, there were a lot of questions we did not get to. James David will follow up with you to get you an answer. Also, huge amount of value in that. So thank you, James David. Until next month, everyone, thank you for coming. Thank you for your attention. Barlow and Williams, thank you as always. This ends the webinar.